Welcome back to Court TV Live. I'm Michael Ayala. We'll get you inside the courtroom for the sentencing in the Irish firefighter rape trial in Massachusetts in just a moment. But first, we have these updates and other cases that Court TV is tracking. In Virginia, Abby Zwerner, the plaintiff in the first grader shoots teacher's civil trial, testified today that she thought she had died after being shot by her 6-year-old student. Zwerner is suing Ebony Parker, the assistant principal at Rich Neck Elementary School at the time of the shooting. Zwerner claims that Parker failed to take action after being warned several times that the student had a gun. And in Florida, the state rested its case in chief in the murder of Julio Foolio trial. The defense began its case by calling a member of a rival gang. The defense case resumes tomorrow. Alicia Andrews does face life in prison if convicted. And in New York, rap mogul Sean Diddy Combs is asking a federal appeals court to consider the legality of his conviction and his sentence on prostitution-related charges. Earlier this week, his attorneys filed motions asking the Second Circuit of the Court of Appeals to hear oral arguments next April. Combs is scheduled to be released in May of 2028. All right now, I want to get you back to Massachusetts for the sentencing of Terence Crosbie in the Irish firefighter murder trial. A jury convicted him last Friday of raping a woman at a Boston hotel in March of last year.
Thank you, Your Honor. And Abby, can you tell the jury your name, please?
All right, so that was obviously Abby Zwerner from a different trial. Well, today, Crosbie faced the victim and the judge to learn his fate and his sentencing. So let's head to court now, where the prosecutor is continuing to lay out her recommendations for sentencing in her opening statement. We do want to let you know that we are still under that court order not to broadcast the victim's name, so if your audio drops, that's why.
The defendant at the time, he was a 30-year-old paramedic and firefighter, someone who would have pledged to do no harm and someone who society trusted. He wore that mantle and walked around as a purportedly safe person. And to put it bluntly, most people in society are against rape. They are anti-rape, and here the defendant publicly posted his own public endorsement of rape. And even better if he found the woman attractive and thought that he might get away with it. And then nearly 7 years after posting this statement, the defendant traveled to Boston and he committed a rape that he likely believed would go unreported because he was outside of his community. He was outside of a place where people would recognize him, and he chose a sleeping stranger. And the Commonwealth does not seek to punish the defendant as a result of uncharged conduct, but that public statement by the defendant as an adult, as a firefighter, as a paramedic, it reflects an extremely dangerous and predatory mindset. And it also informs what his intent was in what he did to the victim here. And it's consistent with him posing a future threat to women. I would note that the defendant has provided letters to the court in support of his character, some from people who appear to know him well, others from people who seem minimally familiar with him. And this is something that happens in the sentencing phase of these cases. Letters come into the court saying this is totally inconsistent with the man who we knew. And I would say that the people who wrote those letters, they know one side of the defendant, the one who presents himself as a pillar of the community and an upstanding family man, a hero and a first responder. But people are multifaceted, and someone can present themselves one way at home and in the community where they're known, and in a totally different way when they step outside of that.
Do you know if the friend with whom he tweeted about Stockholm wrote a letter?
I actually don't, Your Honor, I'm sorry. I know that there are many members of the Irish Fire Brigade who wrote letters, who I think based on the public nature of the defendant's tweet, and others were likely aware of that, but the defendant continued on in his employment. So those are all people who knew one side of Terence Crosbie, but Terence Crosbie is also now a convicted rapist. He is someone who flew to Boston and he raped a sleeping stranger inside of a hotel room. And the people who wrote letters on his behalf clearly have not experienced the side of Terence Crosbie that he brought to Boston and that he chose to inflict on the victim here. At this phase of sentencing, I'd also note that there's a narrative often from the defense of leniency and mercy and seeing the whole person. But Terence Crosbie was not lenient with her. He showed her absolutely no mercy. He targeted her, he hijacked her body for his own sexual gratification. He didn't take into account the whole person, the fact that she's a sister and a daughter and someone who's out there in the community doing good works. He targeted her simply because she was there, because he wanted it, because he thought that he could do it and he thought that he could get away with it. And while the Commonwealth truly hopes that the defendant can rehabilitate himself while in prison, the Commonwealth has essentially no control over that. And unless the defendant accepts accountability for his actions, acknowledges that he did this and acknowledges the harm that's caused, stops pointing to others to blame, rehabilitation isn't going to happen. But until that happens, which will likely take a significant amount of time while incarcerated, until he does that, he just shouldn't be permitted to move freely in society. To allow that would be at the expense of women's safety. And the risk here is too high, and the consequences of acts like the defendant's, they're simply too devastating. So we respectfully request that the court adopt our recommended sentence, and I would ask that the court hear from this time.
All right, we're ready for come forward to the witness stand, please.
All right, just to be clear, he is facing up to 20 years, but the recommendation is 5 to 7 because he is someone without any type of criminal background or any kind of record, and that's the guidelines say 5 to 7 is the right amount for someone in his position. Let's bring in our guest joining us to discuss, criminal defense attorney Silva Megadici. And Silva, great to see you. And I got to say, I remember when we talked about this case, I was sort of on the fence. He had me fooled. You weren't. You really believed the victim in this case. And I didn't say I didn't believe her, but I thought there was some issues with the evidence. But I guess you can call this case the two faces of Terence Crosbie by the way the prosecutor is sort of laying it out. I think she's doing an extremely effective job. Your thoughts?
She is, Michael. You know, I will tell you this. We had so many discussions about this. And, you know, I adore you, my friend, and thank you for having me on the show again. I think there was, underneath it all, I do think there was reasonable doubt, which I know is a moot point right now, but he did himself in, Michael, and you and I talked about it. The fact that he talked about masturbating to kind of explain the presence of the DNA, the fact that he told the officers that, you know, oh, did you claim someone pinned her down? I think that really stuck in the jurors' minds. I think the prosecutor is doing a wonderful job. It's very difficult in cases like this to leave your emotion out the door. A lot of times as defense attorneys, we're able to use that compassion, emotional argument. But she's doing a fantastic job at putting a lot of emotion, and this is her time to shine. She's been working so hard on the case. The victim, in her statement, had actually thanked the prosecutor for her tireless work. And a lot of times, Michael, in these he said, she said environments, there's so much hatred for the victim, right? And a lot of times it's not right. We can attack the facts, but we shouldn't attack the victim. And I think this is an opportunity for the victim's voice to be heard in a very non-judgmental way. She got the verdict she wanted and let her emotions out. And what I love about the prosecutor, she's telling the victim's story in the victim's voice in a lot of ways. So it's a really beautiful job.
Yeah, and I gotta say, we heard a text message that he sent to a friend. And this was, I think, in 2017, she said. And the guy's talking about going to Stockholm, and he calls it the unreported rape capital of the world. And first thing that comes to my mind is, who thinks like that? Who talks like that? How is that even in anybody's mind? Clearly the judge, they wanted to bring it in. The judge said no, it would have been too prejudicial. But that's got to sort of turn your head around. It turned my head around. I said, if that had been a trial, he would have had no chance in this case. But it certainly turned my head around as to who this guy just might be, especially when he's abroad, away from home. Who knows what he's like at home either?
It's so true. Michael, it's so true. Look, his testimony didn't do him any favors in this trial, and these comments, we're going to see more and more of these evidentiary issues come in, which is really going to color his credibility for anyone who thinks he's still innocent. And it is true, it's incredibly prejudicial. You know, everyone says things that are really in poor taste, and a lot of it is not allowed in court because it's just not relevant. But for someone like this to text something like that, it gives you the icks, Michael, that ick feeling that you realize there's something more here. And I will tell you, Michael, like I said also when we talked about this case, the victim came out unbelievably credible. And the one thing the viewers and us don't have is the view from the actual courtroom. I think if it was that powerful on TV, imagine how powerful her testimony was in person.
Yeah, fair enough. All right, Silva, thank you so much for that. I want you to stand by. We're going to take a break. Coming up next, we're going to hear that emotional impact statement from the victim. That's next when Court TV Live returns.
These past 19 months or so have been horrible. Unlike many survivors, I'm so fortunate that I have the support of my family, friends, and boyfriend. As without them, I don't know that I could have made it through not one, but 2 trials and sit here today.
6-year-old shot his teacher.
Their side battling that it is part of the job, just outrageous.
The first grader shoots teacher civil trial. Live coverage today on Court TV.
Tonight on Closing Arguments, an Irish firefighter convicted of raping a woman in Boston was back in court for sentencing. We'll show you everything you may have missed from today's hearing.
Closing Arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
Welcome back. We are bringing you the sentencing hearing in the Irish firefighter rape trial going on in Massachusetts. The victim is now speaking. Please be aware that we are still under that court order not to say her name or show her face.
Sitting down to write this was one of the most difficult things I've had to do. Saying it out loud will be even harder, so please bear with me. Speaking these words today is more painful than testifying about the facts of what happened on March 15th, 2024. How can I put into words how this rape impacted me, as it has impacted me in so many ways and changed my life forever? The trauma brought upon me that night has hurt my health, my work, my friends, my family, and the sense of safety and security and well-being I knew every day before I was attacked. I struggle with making friends as easily as I could before I was attacked. I have nightmares that have frightened me ever since. I avoid going to places that I associate with that night. I feel dread when I walk past the Omni Parker, which is so close to many of the places in Boston that I once looked forward to seeing. My old law school, the Common, restaurants where I meet my friends for dinner. I am reminded constantly of the horrible thing that was done to me. It has been a struggle to heal and to feel that I can grow back into a happy person who enjoys her life. My work depends on focus, confidence, and building a rapport with the many people I work with and meet every week. Since the assault, I have struggled with anxiety and fear that have made it difficult to perform my duties and serve my clients. I find myself second-guessing my decisions and feeling distracted during cases, something that never happened before. Stand up and speak in front of a crowd of strangers. I don't feel comfortable when I meet new clients at clinics. I used to consider myself naturally very outgoing, but now it takes me a long time to feel comfortable with people. Working in my job once felt like a calling, but now it often feels difficult and overwhelming. My health has suffered. I've experienced constant stress, sleepless nights, and panic attacks. I've needed ongoing therapy and medical support just to manage daily tasks. I find myself descending without warning into unhappiness that I cannot control. I feel bleak and lonely when I otherwise should feel happy and loved. The emotional toll has extended to the people closest to me. My parents worry constantly about my safety and well-being. My friends, boyfriend, and siblings have seen how much this has changed me, how I've withdrawn, how I carry a weight that wasn't there before. Their lives have been changed by seeing someone they love needing so much support and struggling to find peace. My faith teaches me the importance of forgiveness, not in order to excuse what was done, but to begin my own healing. I hope to gain the strength to let go of the anger and pain so that I can move forward in peace. I wish that the day would come when I can move beyond what happened and reclaim my life and the joyful spirit I had. But it breaks my heart to know that we live in a world where someone can do such a horrible thing to another human being and not have the decency to hold themselves accountable. My rapist has never offered an apology or any indication of regret for what he did. It frightens me to think that someone could attack another person and never feel the need to apologize or show any sense of remorse. I struggle to heal, knowing that a person like this can exist in the world and will one day walk free again. This crime has had an impact that is so much more than the moments of the attack. It's disrupted my sense of security and self-confidence in the months since. I'm working every day to rebuild my life, to regain the strength and stability I once had. I ask the court to consider the lasting impact this has had on my health, my well-being, my work, on the lives of those who love me and have stood by me to support my healing. These past 19 months or so have been horrible. Unlike many survivors, I'm so fortunate that I have the support of my family, friends, and boyfriend. As without them, I don't know that I could have made it through not one, but 2 trials and sit here today. I also wanted to take this time to thank the prosecutors, Aaron Murphy and Daniela Mendez, for all of the work they put into the case, for believing in me, and to also all the witnesses, most specifically Detective McDonough, who took the time out of their day to testify on my behalf and ensure that the jury heard the truth, that Terence Crosbie is guilty. No one should ever have to go through what I went through. Terence Crosbie raped me and thought he could get away with it. While I will continue to struggle to get back to my former self, I applaud the justice system for getting it right this time. Thank you, Your Honor.
One can only hope that that young woman finds her way back to who she is and who she wants to be. And let's bring back in Silva Megadichian, criminal defense attorney. And Silva, when the prosecutor was talking about this crime, she called it a blitz rape, stranger crime. And then she said he violated her in the worst way possible. And I think her words bear that out.
Absolutely, Michael. I mean, you know, this encapsulates, honestly, every victim's journey and story. A lot of people think that defense attorneys that, you know, we are the devil and we don't care. You know, just the opposite, Michael. We do what we do because everyone has a constitutional right to a defense. But we don't ignore what the victim's stories are. We can't. We believe in our clients, we fight for our clients, but we understand human suffering and being violated. As a woman as well, there are so many women who are victims of assault, sexual battery, and nobody feels comfortable enough to fight for their justice. And she did, I think partially because she's an attorney, partially because she's strong. And she's a 29-year-old woman that finally got her story out. I don't think there's anything more powerful, Michael, honestly, than when you finally can face your accuser or face the man who violates you and say, you deserve this, you hurt me. And there's a power and a closure to that, and it's obvious in her voice. She got it. And this is when the justice system, honestly, when we give voice to those who are the voiceless, whether the defendant or the victim, this is a time for healing. And I think she did a beautiful job. It's, you know, Michael, again, I'm a defense attorney. You know I fight for my clients. But stories like this, it makes you realize the system, we have to have a balance, a common courtesy, and an understanding that victims have a voice too.
Yeah. They absolutely do, and extremely well said. I couldn't agree more. It's interesting, though, you know, I agree with you. There seemed to be, she was taking some power from the idea that she was able to find the courage to testify in court, and finally, after a second try, got a conviction. But she did mention still, this defendant has not apologized, and he hasn't shown any remorse. Just highlights the fact that that, too, is an important thing in a case like this. And I don't suspect it's going to happen. He is going to appeal the case, so I don't suspect that's going to happen. But, boy, that would be helpful as well.
Michael, we always advise our clients, no matter how much remorse they feel, the one thing not to do is admissions. You can do an apology in a way that doesn't admit the crime, but yeah, no attorney in their right mind is going to have their client admit on their watch. And so she's not going to get that. But, you know, it's her way again of healing, and I don't blame her. It's understandable. It's just not going to happen.
Yeah, it's just not going to happen. All right, Silva, stand by. We do have to take a break, but before we do, I want to turn to Florida quickly, where the state has rested its case in chief on day 7 of the Julio Foolio murder trial. Alicia Andrews is the first of 5 defendants on trial for last year's murder of up-and-coming rapper whose real name is Charles Jones. Now, she is charged with first-degree murder and conspiracy to commit murder. Jones was fatally shot during an ambush by rival gang members in a hotel parking lot in Tampa. Jones had just finished hosting a party for his 26th birthday at a local nightclub. And prosecutors say that Andrews texted Jones to set him up and shared her location with her co-defendants, leading to the ambush as Jones tried to escape in his car. The lead detective returned to the stand for today to face cross-examination by the defense before the state rested. Andrews' attorneys questioned Detective Ramos about the lack of evidence directly linking Andrews to the murder of Jones.
So your testimony today is that there's evidence, I guess in the totality of the evidence, you know that Alicia Andrews, you know definitively that Alicia Andrews knew that Charles Jones was going to die.
Again, there's no singular piece of evidence other than a detailed confession that can tell me what's going on in someone's mind. So there's an inference or a logical deduction based off of all of the evidence that we've compiled in this case.
So you're making inferences?
It's evidence.
You read the message in Alicia Andrews' phone?
I have reviewed them.
All right, and does it say she wished Charles Jones would die?
I can't recall the specific verbiage.
All right. Does it say she wanted to kill Charles Jones?
No.
And remember, Andrews faces life in prison without parole if she is convicted. The jury is expected to get the case at some point tomorrow. All right, folks, we do need to take that break now. Coming up next, convicted rapist Terence Crosbie speaks ahead of his sentencing in the Irish firefighter rape trial. We'll hear what he has to say. But it's what he didn't say that stands out. So keep it here on your front row seat to justice.
My faith teaches me the importance of forgiveness, not in order to excuse what was done, but to begin my own healing. I hope to gain the strength to let go of the anger and pain so that I can move forward in peace. I wish that the day would come when I can move beyond what happened and reclaim my life and the joyful spirit I had. But it breaks my heart to know that we live in a world where someone can do such a horrible thing to another human being and not have the decency to hold themselves accountable. My rapist has never offered an apology or any indication of regret for what he did. Terence Crosbie raped me and thought he could get away with it. While I will continue to struggle to get back to my former self, I applaud the justice system for getting it right this time.
Welcome back to Court TV Live. I'm Michael Ayala. Just days after his conviction, Terence Crosbie is back in court for his sentencing in the Irish firefighter rape trial in Massachusetts. It was his second trial on allegations that he raped a woman at a Boston hotel in March of last year while he was visiting from Ireland. His first trial ended in a mistrial, but this time jurors convicted him of rape. I want to get you back into court now for the defense's sentencing recommendation and their statement to the court. And then we're going to hear from Crosbie as well. Please be aware that if your audio drops out, it's because we are not allowed to broadcast the victim's name.
Your Honor, Mr. Crosbie stands before you convicted of a single count of rape.
No aggravating factors were charged. He's a first-time offender with no prior criminal history. The Commonwealth is asking for 9 to 12 years, 4 to 5 years higher than the guidelines range of 5 to 7 years, which takes into account this charge. We're asking for an imposition of 3 to 5 years, a sentence which touches the low end of the guidelines and takes into account mitigating factors, the circumstances, and the impact on this particular defendant. Mr. Crosbie is 39 years old. His offense conduct encompasses 15 minutes of those 39 years. That is not to excuse or diminish that conduct or his conviction. It is serious, it is egregious, and regrettably it will have a long-lasting impact on the victim and others. That said, Mr. Crosbie's life amounts to more than that 15 minutes and this conviction. He is a husband and a dedicated father to 2 young daughters. They will be without him for whatever length of time you impose, which will be painful for him and for them. He has no criminal record and was a public servant for over a decade, serving as a firefighter and paramedic, doing dangerous work to serve his community. He has tremendous family and community support. His wife and friends were here for weeks. His father is still here supporting him today. And as you noted, he received over 80 pages of letters of support submitted on his behalf, attesting to his good character and the positive contribution he has made and the positive impact he has had on their lives. Again, notwithstanding an 8-year-old tweet that was admittedly detestable and in poor taste, but we would argue is not reflective of the man he is and has been, which is more accurately captured in those letters. Again,
fortunately, there are not many people who would send a text like that.
You know, I can't speak to what his mindset was 8 years ago in setting that, but I can tell you that, again, the 39 years of his life in his public service and the letters of support that attest to his character are more reflective of who he is and not a single moment of a regrettable choice to send something like that. I would also note that this conviction is not going to define who he is, who he has been, or who he will be in the future. He will be punished. He will put in the work to be a better man. For these reasons, we ask for leniency and a 3 to 5 year sentence. Additionally, whatever sentence Your Honor imposes will be particularly harsh for Mr. Crosbie relative to similarly situated defendants. He's a foreigner serving time in a faraway country without easy access to support from home, family, and community. He will lose his job, and he will not be able to resume that career after he is released. He was the primary breadwinner, and the expectation is he will not be able to return to the home he left. By that time, whenever he's released, it's likely that they'll have to have sold that home. He will miss formative years of his daughter's childhood and time with his wife. This is perhaps what he views as most punitive. For those reasons, we ask for leniency and a 3 to 5 year sentence. Finally, and respectfully, we believe the Commonwealth's request of 9 to 12 years is unsupported by the guidelines, particularly for a first offender. It's excessive relative to what the guidelines suggest and what they take into account for this charge. I would also note that the last year, Your Honor sentenced another public servant, an MBTA police officer convicted of 3 counts of rape amongst 2 victims, while uniformed, armed, and in and around his cruiser, to 4 to 6 years of imprisonment. Where here there's a single count against 1 victim, 9 to 12 years or even 4 to 6 would seem to be excessive relative to that, especially where there are markedly different facts.
Do you know the facts of that case?
I have reviewed the opinion in that case, Your Honor, yes.
All right, so you're aware of how egregious this particular rape was?
Yes, Your Honor. For those reasons and for the reasons in our sentencing memorandum, we humbly request you impose a sentence of 3 to 5 years with credit for the nearly 20 months already served. And Mr. Crosbie would like to make a very brief statement.
Your Honor, I thank you for giving me the opportunity to speak here today. I understand the seriousness of the situation. I respect you, I respect this courtroom, I respect the jury, and I respect everybody involved in this process. I have the deepest respect for this court and the legal system. I recognise the weight of this court's responsibility, and I appreciate the time and attention the court has given my case. I've dedicated over 18 years of my life selflessly serving the people and the citizens of Dublin, and I hope to contribute to society again someday. I ask that the court take into account the large number of character references that have been submitted by my family, work colleagues and people from both sides of the world, including the cities of Dublin, Boston and further afield. Also, please consider the impact on my family, including my wonderful wife and my two beautiful young daughters, who not only wait at home in a different country from me, but also rely on me as the single sole main provider of our family and our family home. I ask that you please take these things into consideration, Your Honour, and I thank you again for giving me the opportunity to speak here today. Thank you.
All right, so respectful from Terence Crosbie. Of course, no apology. Again, he is appealing, so one can understand that. I think there are ways he could have said something a little bit nicer in terms of that victim, but he didn't. The judge has a real difficult decision. Defense is asking for 3 to 5 years. The guidelines say 5 to 7. The state is asking for 9 to 12. Keep it right here on Court TV Live, because when we come back, we're going to bring you the judge's sentencing. So keep it here on Court TV.
6-year-old shot his teacher.
Their side battling that it is part of the job. Just outrageous.
The first grader shoots teacher civil trial. Live coverage today on Court TV.
Tonight on Closing Arguments, an Irish firefighter convicted of raping a woman in Boston was back in court for sentencing. We'll show you everything you may have missed from today's hearing.
Closing Arguments with Vinny Politan tonight at 8, 7 Central, only on Court TV.
Welcome back. We do want to head back to Massachusetts now, where the judge is addressing the defendant and then he issues his sentence. And this reminder, if the audio does drop out, is because we're under court order not to reveal the victim's name.
There are two components to achieving justice at trial: a just verdict and a just sentence. A just verdict relies on the advocacy of the lawyers, the evidence presented, and the fairness and wisdom of the jury. The advocacy at this trial was excellent, for both the Commonwealth and the defense. All the lawyers contributed to presenting the evidence thoroughly, with the evidence examined and argued from opposing points of view. Massachusetts sets a very high bar for proof beyond a reasonable doubt. While every state and the federal government use beyond a reasonable doubt as the standard of proof in criminal cases, each jurisdiction defines reasonable doubt according to that jurisdiction's own law. Our Supreme Judicial Court in Massachusetts has defined beyond a reasonable doubt, and I did instruct our jury that proof beyond a reasonable doubt requires the highest certainty that one can have in matters of human affairs. That is a very, very high standard of proof. I doubt that there is a higher standard of proof anywhere in this country. And that is the standard of proof that the Commonwealth is required to meet and did meet in this case. The jury in this case heard the victim's testimony, the corroborating evidence, including video evidence, medical records, DNA evidence, and hotel key card evidence, and the jury heard the defendant's testimony. The victim is an accomplished woman with a challenging and meaningful job, and she has devoted her professional life to helping people less fortunate than herself and less fortunate than most of us in this courtroom. The jurors evidently concluded that she is a reliable and honest person. The jury certainly saw that in addition to being a reliable person, the victim had absolutely no motive to lie. She did not know the defendant. Moreover, she did not know who raped her. She did not say it was the defendant. Instead, it was the other evidence that proved the defendant's identity as the rapist. The jury also heard that the victim immediately resisted this rape when she woke up, got away from the rapist's grasp by struggling and fighting, continued to resist the continuing violence in the hotel room for several more minutes, escaped from the rape scene as quickly as she could, and got herself to the safety of the hospital. The evidence was overwhelming on the issue of identity. The defendant was the co-occupant of room 610. Video showed the defendant walk towards room 610 at the critical time. Key card evidence proved that he entered room 610 just before the rape and was present in the room at the time of the rape. He admitted to police and in his testimony that he was in the hotel room with the victim at the time of the rape. The jury was able to evaluate the corroborating evidence. Most importantly, the victim made a prompt, accurate, and descriptive first complaint within moments of escaping from the assault. The jury, no doubt, found this extraordinarily important in establishing the victim's credibility and reliability. In addition, the important points of what the victim said about the events leading up to the sexual assault were corroborated, much of it by video evidence from the Black Rose, the Omni Parker House, and the City of Boston security cameras. The jury also considered forensic evidence. The DNA evidence showed 2 male contributors to the DNA mixture, which not only supported the victim's credibility, but disproved the defendant's claim and the defense theory that there was only one sexual partner and there was never a second male who raped the victim. The jury also had consciousness of guilt evidence. Police interviewed the defendant on March 16th, and he made 2 statements that revealed more than an innocent man would know. He knew the rapist held the victim down on the bed, and he knew investigators may find DNA from his ejaculation. And then the consciousness of guilt evidence that was especially probative. The defendant, rather than marching with his brigade at the parade, flees at the first opportunity. He boards the plane, and he is removed from the plane and arrested by police. Imagine what the defendant, with his guilty conscience, thought when that Aer Lingus jet turned around and went back to the gate, and the police walked down the aisle, approached him, and asked, "Are you Terence Crosbie?" The jury had the chance to evaluate his testimony. He went from bar to bar with his buddies, but he was hardly drinking. He spent most of the time at the Black Rose trying to entice a woman to have sex with him, but when she was ready to say yes, he said no. He would never use the word friend because he is Irish until moments later when he did use the word friend naturally and spontaneously. I don't think the jury missed that one. He came all the way to Boston to march in the parade, but changed his flight and left early because he found the door of his hotel room was open. As shown by the verdict, the jury concluded that the defendant lied to them. A fair-minded person with common sense who views the evidence in totality without bias or preconceived notions can see that once again, the jury system in Massachusetts has worked. The jury relied on the evidence in agreeing unanimously on a fair and just verdict. What remains is sentencing, and I need to consider the recommendations and the arguments of the lawyers, the materials they have submitted, as well as consider Mr. Crosbie's statement, as well as consider the victim's statement of impact. So the court will be in recess for 15 minutes for me to make those considerations.
Court, all rise, please. Court May 06 is now back in session. Please be seated.
Right. In Massachusetts, we do have sentencing guidelines. We refer to them as advisory because they don't compel a judge to any particular result. They're merely to advise us on what defendants in similar situations might receive. So the guidelines for a person who has committed rape when that person has no other criminal convictions recommend a top number of 5 years to 7.5 years. For example, 4 to 5 years or 6 to 7.5 years. So I do take into account the guidelines, but in taking them into account, they're not going to dictate what the sentence is. I do consider whether they're aggravating or mitigating factors. In this case, the victim was safely asleep under the covers in a locked hotel room. The defendant attacked a woman who was asleep, defenseless. Mr. Crosbie committed a predatory sexual act. It is an act of extraordinary sexual violence. The victim resisted, and Mr. Crosbie persisted. Mr. Crosbie prolonged the violence, the fear, the trauma as he continued to assault and batter the victim as she tried to escape the sexual assault. This level and length of violence is an aggravating factor. The Commonwealth's recommendation of 9 to 12 years is a reasonable recommendation, considering the violence, the trauma he inflicted. I also consider as a mitigating factor Mr. Crosbie's work in his community, both with his family and as a firefighter, first responder, paramedic. I have a great deal of respect for the work that people in those public service jobs do, and I do consider that a mitigating factor, what he had contributed to his community through his work and family life. when I put together all of the factors, including the aggravating and the mitigating that I mentioned, the sentence is going to be not less than 7 years, not more than 9 years in the Massachusetts State Prison. Please impose the sentence, Clerk Citano.
Mr. Crosbie, please stand. After a verdict of guilty on indictment number 2024-244, offense 001, charging rape, the court orders to be imprisoned at the Sousa Baranowski Correctional Center for a term of not more than 9 years, not less than 7 years. You have 593 days of jail credit. You're notified of Rule 64 to the Appellate Division within 10 days of writing. You're notified of Rule 65. Your $110 DNA fee is waived. Your $90 victim witness fee is waived. You stand committed.
All right, the court will be in recess.
Court, all rise, please.
All right, there you heard it from the judge. A really well-reasoned approach to this case ends up sentencing Terence Crosbie to 7 to 9 years in prison, not to serve less than 7 years. He's already served about 1 year and 8 months, so you'll take that off the 7 years. So just about a little bit over 5 years before you'll be eligible for parole. Let's bring back in my guest, criminal defense attorney Silva Megadician is still here with us. Silva, your reaction? As I said, I thought the judge gave a very well-reasoned approach to it. Clearly, he was very commending of the jury's work in this case and the victim and her courage to come forth and testify. So your thoughts?
Yeah, I think, Michael, if only every judge can be this well thought out. I think he gave really a reason in every capacity why no one should judge what he put down in punishment. And I also like that he thanked both sides for really fighting for their sides in a very ethical and compassionate way. Look, I do think it's the right sentence. The fact of the matter is he kind of really adhered a little bit to what the defense was saying and a little bit to what the DA was saying and gave him what the judge thought was appropriate. And, he also said in there, look, this man was a firefighter, seemed to be a good family man and did his part with the community and took that into account. In cases like this, Michael, we don't expect anything less. Honestly, he has to serve his time. And I think it's a very reasonable sentence. And he's just going to have to be away from his family and learn the lessons and do better.
Yeah.
And do better.
Yeah, no question. And hopefully he'll learn from his mistakes. The judge alluded to that a little bit. He can come out of this a better man. I want to get your reaction to his statement to the court. Again, we kind of predicted there would be no apology. There wouldn't be remorse for various reasons. As I mentioned at the time, I thought there could have been something said to the victim without sort of, breaching any of those things you're worried about as a defense attorney when you are appealing a case. What did you make of his statement to the court?
Oh, Michael, per usual, you're spot on. I mean, it's funny because I also criticized, he did well with testifying, but he seemed very medical in the way he approached it, very plain. And he had that same plain kind of separation affect when he was making a statement. I thought it was a very ineffective statement. The funny thing is I don't think clients realize how important their statements are when a judge is considering what sentence to give you. And Michael, you said it perfectly. Look, you can apologize without apologizing and affecting your appeal. You can do something that shows the court that even though you're upset with the verdict and you might not want to, accept responsibility per se, there are ways to do it where the judge understands that you are sorry. And he didn't do himself any favors. I think this kind of gentleman, the way he was talking, he's not someone who talks with passion or emotion. And honestly, his words lacked any kind of sympathy that someone would have for him. So he missed an opportunity. He really did.
Yeah, he was soulless, is the way I felt. There was like no soul there. But I will tell you this, I was surprised to see the support. I was wondering what kind of support he was getting from his colleagues and folks back home. Sounds like he had, according to the defense attorney, 80 pages of support. So I thought that was decent. But again, it goes back to this two faces of Terence Crosbie. That's what you can probably sort of call this case. All right, Silva Megadician, thank you so much, as always, for your wonderful insights. Always a pleasure to have you on the show. Folks, stick around. Coming up next, we're going to review the 3 things that we've learned today in the cases that we've been covering from coast to coast right here on Court TV. Yeah.
You're on the air.
Oh, here are three things that we've learned on this Thursday. First, in Virginia, plaintiff Abigail Zwerner took the stand today in the first grader shoots teacher civil trial. Zwerner filed a $40 million lawsuit against former assistant principal Ebony Parker, claiming that Parker ignored the teacher's concerns that the student had a gun. Well, today, Zwerner told the jury that another teacher told her that two students said that JT had a gun and that while the teacher went to inform Parker, she kept an eye on JT. She also said after she was shot, she thought she had died. Court is dark tomorrow. Testimony is set to resume on Monday. Second, Sean Diddy Combs is asking a federal appeals court to expedite his conviction on 2 prostitution-related charges and his 4-year prison sentence. Combs was acquitted in July of sex trafficking and racketeering charges that could have put him behind bars for life. Well, now Combs' lawyers are asking oral arguments in his appeal occur in April, arguing Combs could finish his sentence before his appeal is heard on a normal timeline. Combs is expected to be released in May of 2028. And third, a former University of Kentucky student charged in an infant's death has been ordered to wear an electronic monitor. Lakin Snelling was arrested at her apartment after her roommates called police to report finding the deceased infant in her closet. She's charged with abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. Snelling has also been ordered by a judge to home confinement at her father's Tennessee home. Right, I'm Michael Ayala. It's a pleasure being with you. Thank you so much, as always, for being with me. Coming up next on 48 Hours, it's the death of Conrad Roy III and the case against the Michelle Carter, the woman prosecutors say influenced him through text messages.